Hey, welcome back everybody. It's Mike Coffin and Amy Bondy. And this afternoon's guest we have is Merrill Baker. Merrill, good afternoon.
Good afternoon, Mike and Amy. It's a pleasure to be here. As you know, I've been a lawyer here in the city of Windsor for approximately 33 years at Merrill Baker Professional Corporation, and it's been my privilege and honor to have served thousands and thousands of families with their legal needs over that time frame. I practice what I call happy law. So I specialize and focus in on helping people when they're buying and selling a home, when they need assistance on a business transaction, or if they need a will or a power of attorney prepared, or advice on the estate of a loved one.
Well, that's great to know, Merrill. And we have a few questions for you, just that we run into things in real estate, Amy and I, and we will make this disclaimer now. We are not lawyers, we're realtors. And if there's a question important enough to ask us that's legal related, we always suggest to contact your lawyer for the proper advice. So Amy, you got a question for Merrill?
So Merrill, what's the importance of having a will?
Well, everyone should have a will, Amy. People are under the misconception that it's only when they have significant funds or assets that they should be doing so. But there's so many reasons that a will can benefit anyone at any time during their life. A will is the only document that's going to allow you to determine who inherits your assets. The will would allow you to give gifts of particular items, for instance, jewelry or artwork, or to deal with pets you may own. The will allow you to appoint a guardian for your minor children. A will would allow you to pick the person you want to be in charge of your estate, somebody you trust, somebody you know is financially wise and will be able to administer your assets in an appropriate manner. The will would allow you to establish trusts. A classic example would be if you're leaving money to children or grandchildren. You may not want them to have full access to that money at age 18. Would they spend it wisely at that age? So you might want to put it in trust and have it controlled by your executor or executrix until they turn 21 or 25. So we encourage people to put in place wills when they can. It's an easy thing to procrastinate about. No one likes thinking about their own death, but it's certainly something that should be done.
That's wonderful. That's great, Merrill. I know it's a big deal when people die without a will, and it becomes an estate nightmare for the survivors.
Well, it certainly slows things down, and often you'll have disputes within the family as a result of there being no will. Who's going to be the person that applies to the court? There'll be fights over items, fights over money are all too common, regrettably.
Now, Merrill, can you explain to us when we do a real estate transaction, what is probate?
Oh, absolutely, Mike. So when a person dies, there has to be an application to the court. People often call it probate. It's now to obtain a certificate of appointment of a state trustee with a will. Big, long way of saying probate effectively. And probate is obtained because it's the certification from the court that the executor or executrix has the authority to deal with the estate, has the authority to sell assets or distribute assets. And that's evidence to anyone dealing with the estate that they can proceed with whatever that transaction is. So obtaining probate can be a lengthy process. There's the original will that would have to be submitted to the court. Various forms would have to be completed. And it probably doesn't shock anyone that the government will want some money as well. So there's a probate fee or tax really that's paid at the time of the application. It's about 1.5% of the asset value over $50,000. So it's not as severe as many people think. But once again, the province of Ontario will be getting some of your money.
Merrill, would you be able to explain what an executor is in terms of real estate?
Sure. So the executor is appointed under the will. So the will define who the executor or executrix is. We often lump them together now and just call them estate trustees. That person is the person that's going to be charged with taking all the steps to administer the estate. So in a real estate focus, that's the person that's going to be finding the appropriate agent, Mike and Amy, finding the proper price to list it at with advice from their agents. And they'll be the party that will ultimately be selling the property. So this ties back into the probate question, because most of the time, there are certain exceptions, but most of the time probate will be required for the executor or executrix to be able to sell the property. And closing will be delayed until that probate's obtained. And we're currently experiencing considerable delays sometimes in obtaining probate from the courthouse. So it's important to start the process early if there's a home that's going to be sold as part of the estate.
So that's a good heads up to a potential seller, that sometimes even though they may want to rush and move through the estate process, that they obtain good sound legal advice on what their role is and how important their role is to activate whatever it is they need to do to have signing authority.
100%, Mike. The executor, executrix, they're fiduciaries. They're there to protect the estate and to do what's best for all the beneficiaries. So sometimes rushing isn't necessarily the appropriate response after somebody's passed away. Taking the steps in a measured manner and making sure you're properly protecting the assets and properly valuing the assets is just wise.
All right, I've got another question for you in regards to real estate. What types of power of attorneys are there in regards to real estate?
Well, there's two kinds of powers of attorney just generally, right? And there's always, people get confused, well, what's the role of a power of attorney? But I already have a will, do I really need a power of attorney? And of course, the will only takes effect upon your death. It gives no power to the estate trustees until your death. So in conjunction with the will, there will be a power of attorney for property. Now that's sort of a misnomer because it's not limited to just a house or some land. Property is a general description of anything you can do financially effectively. So it encompasses bank accounts and investments and many other items. So a power of attorney for property, you can name a party, named your attorney, to take steps on your behalf. Normally, the power of attorney for property is not limited or to become effective upon your incapacity. It's normally going to be valid and usable by the person you picked the moment you sign it. So they're very dangerous documents to a degree too. You have to have absolute trust and faith in the person you're picking as your attorney, because they become you effectively. It's like handing somebody a blank certified check almost, because with that power of attorney in their hand, they can do what you could do, including sell the home that you may live in while you're at the mall.
Well, it shows you that, again, I reiterate, get good sound legal advice when you start getting into these documents. Amy?
Merrill, what is title insurance?
Title insurance is a form of insurance that people buy when they're purchasing a home. It's often mandated by the lender because in the olden days, before title insurance was in existence, the lawyer would be certifying title and there'd be a survey obtained, hopefully an up-to-date survey. There's costs involved in all of those steps, and title insurance has been commonly used in Ontario for probably about 20 years now. And it's a great product because it helps the buyer on many levels. It protects the buyer from title defects, protects them from fraud that might be associated with the home. And people talk about identity theft, and they're worried, well, what if somebody puts a mortgage on my home and pretends to be me? That would all be covered under the title insurance product. Protects you against liens or outstanding work orders. There's a whole series of things that gives you coverage for. It's a one-time fee, so it's not like your regular insurance you hear about, like your house insurance you're paying annually. This is just once, and it's good for as long as you own the home. So that's a great thing. It is something that, from the perspective of when you're closing your transaction, it is an additional cost. And on a $500,000 home, for instance, with a usual kind of mortgage on that, the cost of the title insurance would be about $450. But as I said, it's a one-time fee.
Well, I think it's money well spent, particularly with the identity theft and some of the old properties that get scooped up on these. It's for $450 to $500, $600. It's certainly a sound peace of mind. Now, while we're talking about costs, can you explain closing costs and what maybe some typical closing costs buyers can look forward to?
Certainly. So you've got your purchase price, of course, and you paid your deposit, so that gets subtracted, but there's always going to be an adjustment on closing for real property taxes. So the seller may have prepaid some of the property taxes, so that would increase what you're going to have to pay on the day of closing. You'll also be paying for your lawyer and all the costs and monies the lawyer spent on your behalf to investigate title to the property, to investigate the seller to make sure they don't have any judgments against them, to make sure there's no liens on the property itself, to determine that title has properly transferred over the years, to make sure effectively that you're buying what you think you're buying, Mike. That's pretty key because everyone's spending a lot of money nowadays on these homes. So the closing costs would include that. It would also include the government charges. Of course, to register the deed and the mortgage, the government has inherent charges that have to be paid on closing. You'll have your title insurance as another closing. Of course, there's always HST on many of these items.
And included in that, is there a land transfer fee?
That's another big closing cost. So that's probably going to be the biggest cost the buyer's going to have on closing, other than the purchase price itself. So the land transfer tax is a provincial tax that is imposed on any buyer. Now, there are exceptions. If you're a first-time home buyer, this is one of the few times the government doesn't collect a tax from you, but there's a cap on how much they'll permit you to benefit under that first-time home buyer provision. It's $4,000. Land transfer tax is a huge revenue driver for the province of Ontario. When you pay it, they don't even send you a thank you card. I really think they should. Give you an example. For a $500,000 home, Amy, you'd be looking at approximately $6,475 in land transfer tax. And this tax is a progressive tax. So the more you pay on your home, the higher the percentage is. And these numbers can get astronomically large depending on the purchase price of your home.
So that's some valuable information when somebody's getting pre-approved through a mortgage broker, that they've contemplated all these costs involved, because on the day of closing, you got to be prepared to move forward. Speaking of closing day, what does closing day look like in receiving the keys? I know in our contract it says to be completed by 6 p.m.
Yes.
And I know you're going to smile when I say that. So can you address that for us?
Sure. Well, closing day is, of course, the most exciting day for the buyer, and it's also the most exciting day for the lawyer, because we actually have completed the transaction and we're there to actually physically hand the key to the buyer. So you mentioned, Mike, the agreement of purchase and sale indicates 6 o'clock. Practically speaking, though, that's not realistic or achievable because the system that is used to transfer property in the province of Ontario, everything's computerized and electronic now, of course, and that system shuts down at 5 o'clock at each business day. Of course, it's not available to close deals on weekends. So it's going to have to be done before that. So from my perspective as a lawyer for many buyers, I try to close as soon as we can. So the clients would have been in well before the closing date to sign probably far too much paperwork in their mind. And they will have delivered to us the monies they have to provide. Then on the closing day, we're waiting for the mortgage company to send the balance of the funds. Now, most mortgage companies are very good at it, and it's normally delivered early in the morning. So then we have to connect with the other lawyer, get the bank drafts prepared, deliver the money to the other lawyer. We receive the keys and all the other documents that are required. We rush back to the office and we give the congratulatory call to the buyer, say, come down and get your key. Usually the window is anywhere from noon to 4 o'clock. We can't predict, it depends often on what the seller's lawyer's doing.
Wonderful. And now when they're purchasing a condo, what does reviewing a status certificate mean?
Well, as you mentioned, status certificates are unique to condominiums, and the status certificate's an important document to review before closing, and often you will build into the agreements, and I've seen agreements from you, Amy and Mike, that ensure that the offer that's been made by the buyer is conditional on the status certificate having been reviewed by the lawyer. The status certificate gives all kinds of information about the condominium itself, not the unit necessarily, but the whole structure, the whole complex. It's going to tell you what the common fees are. It's going to tell you if there are any arrears of common fees. It's going to tell you if there's been any special assessments or any planned. It's going to give you budget information. It's going to tell you the budget of the condominium and whether they lost money or made money. Probably one of the most important things, though, is how much money's been set aside for repairs and maintenance. Now, that's called a reserve fund in a condominium. And it's really important to understand what's there and whether they believe it's going to be adequate for the coming year's expenditures, and to look at the reserve fund study. That's the one that's going to project out, are there going to be increases in the common fees to fund the reserve fund specifically or not? It also tells you things such as, is there litigation against the condominium? These are all important things for a buyer to understand, so they have a comfort that there's no red flags before they proceed.
Thank you. Merrill, what happens to a buyer if they choose not to close a transaction?
Can I leave now?
Yeah.
This is an awful scenario, Mike. Obviously, that's a worst case scenario. And a buyer should do everything in their power to ensure they're not in that position. Often we've seen it occur recently because too many agreements of purchase and sale during that frenzy period weren't conditional on financing or things like that. And then they discovered, notwithstanding their belief they were pre-approved or would be able to get financing, they couldn't. And then you have a scenario where, from the seller's perspective, there's a binding agreement of purchase and sale. And so the seller will then insist upon a number of different things. It's unlikely the seller will just let the buyer walk away or terminate the agreement. The buyer is at risk then of forfeiting their deposit. Buyer's at risk that in addition to the forfeiture of the deposit, that they can be sued for any other losses that the seller may incur. And that could be carrying costs, extra insurance, the lost legals. But the big one and the big worry would be they have to resell it now. What if they sell it for less? If they sell it for less, that seller will have the right to chase the buyer for the difference, effectively the money they lost. So in addition to you losing your deposit, you could be facing a large lawsuit. So if that scenario arises, it's incredibly important that the buyer get legal advice early in the process and is careful about what is being communicated on to the seller directly without having first getting legal advice.
Well, going back to my opening comment, and I try to stress this to our buyers and our sellers, when legal issues do present themselves or you're trying to anticipate something being raised ahead of time, it is so prudent to reach out and speak to the lawyer before you start moving forward with any written binding agreements, either representing the purchaser or representing the buyer, to ensure a clear line of communication to what expectations are and that there are no pending issues, particularly going back to the feeding frenzy when we were having offers that were unconditional. They weren't truly cash offers, they were just unconditional, and then folks were trying to put them together after the fact. Very difficult times, and I'm certain by your response that you had to help people renegotiate their positions, and that's not an easy thing to be involved in, not for anybody.
No, it certainly isn't. And even from the seller's perspective, the seller signed a contract. It was unconditional, as you pointed out, Mike. The seller was moving on. The seller may well have, in reliance upon that, purchased another property, and they were going to use the funds they were going to get. And this is where it gets messy and complicated fairly rapidly.
It starts a train.
Yes.
It starts a train. Sometimes it gets derailed.
Yes.
Well, listen, Merrill, we really appreciate the time you've taken to speak with us today, because these terminologies and these situations are most common to what Amy and I are asked questions about or we're asked to respond to. And I can assure you, over the years of doing real estate, most of our responses is contact your lawyer, simply because it's out of our realm of expertise. We don't want to be the lawyer, we don't want to be the accountant, we don't want to be the advisor outside of just real estate. So we're glad our customers listen to us and call their solicitor and they obtain the information, which really just produces a smoother transaction. Amy, do you have any closing comments?
Just wanted to thank you for your time and for informing everybody of this information.
My pleasure.
How about you? Do you have any closing comments?
No, it's always a pleasure working with the two of you. When I get the agreements of purchase and sale in and I see that either Amy or you, Mike, are the person that's been assisting the buyer or seller, I always know I won't have any worries because the contracts are always well drafted.
Well, we appreciate hearing that, and that's come from experience and having very deliberate and open conversations with you very early in our career, and you providing us with some guidance, which was very simple. Call me. It's just that simple, and I can't stress that enough. Today I actually had a phone call from a potential seller. He raised a couple concerns with me, and I said, listen, here's my thought, but here's what you need to do. Mm-hmm. And so he is reaching out to his solicitor later today, and if not on next week, to obtain what he feels information he needs to do before he moves forward. So again, we practice what we preach. We're glad to have somebody competent like you to reach out to. I know our buyers and sellers appreciate it, because sometimes there's questions that come up. We need to deal with it, and you've always been prompt on the return call. So again, thank you for your time, Merrill, and have a great day.
Thank you.